Today was worn grey, cloudy and wet all day, not the brilliant sunshine we'd had the day before. One might say the mood was similar at the PI, walking back in there, not knowing if it was going to be adjourned. Yesterday wrapped up with the Planning Appeals Commission holding off on a decision until this morning on whether Northern Ireland Environmental Agency's new information would be accepted. The decision was to accept it on the basis that, in their view, the Commissioner's questions were grounded in the statement of case and rebuttals, not in the new material. I thought to myself, what would we have written differently in our statement of case and rebuttals if we had access to this information earlier? This morning, looking around the stage on which all of this is playing out, I noticed for the first time the number of suits in the room. Some beautifully cut, quality, style, broad at the shoulder, narrow at the hip, designed for power and influence, as someone said, as if they all drank in the same club. Masculine energy is definitely to the forefront. Later, I couldn't help but notice an unconscious bias towards this same power in the room, especially when third-party members were speaking, who sometimes had long waits with their hands in the air to answer a question, whilst the DFI and Dalradian barristers, sitting strategically close to the Commissioner, could engage in intimate conversation without even asking permission to speak. The state of affairs continued for some time, creating frustration and anger with third-party people. By the way, that's us. Being forbidden to laugh or clap the day before, we dutifully followed the instructions, making the preposterous presumptions that the same law would apply equally to all parties. Sadly, this was not the case. It seems that some of the suits patently thought they were above the law, laughing and showing contempt a number of times over the last few days. Moving on, it was good to see the Commission pushing Dalradian today for worst-case scenario figures instead of approximations, and to properly detail where these figures were in the application. Yesterday was noticeable that questions like these were not directly answered, instead being kicked up the road like the proverbial tin can. A large part of the discussion in the morning served to highlight big gaps in basic details, not inconsequential elements such as chemicals, tonnage, and the mystery of the disappearing 15,000 tonnes of soil. Words such as flocculants been bandied about. When I looked it up, it comes from an early 19th century English and it means tuft of wool. Apparently this is used in processing the ore. It's a highly corrosive product. Contact with eyes or skin can cause burns, and ingestion or inhalation can cause internal damage. The casual way these strange terms were being bandied about would almost make you believe they were harmless, like warm and cuddly or something. Instead, a Dalradian expert witness compared the concentrate, that is to say, the stuff that comes out after flotation, conditioning, processing with reagents and flocculants, to a glass of orange juice. I almost choked. I imagined him drinking it as I listened to this daft comparison with growing incredulity. There were conversations about whether the DFI have the jurisdictional remit to actually make a decision about the application, as the lack of management agreements between Northern Ireland and the Republic of Ireland leaves the Lochs Agency powerless to discharge many of its functions. If this project was given the go-ahead, we wonder who would regulate it. But that's nothing to worry about. Sure, it's going to be a shared responsibility, isn't it? Finally, the spectre of cyanide raises its ugly head once more. The Commission asked DFI to confirm if cyanide is removed from the process, because apparently it still appears in documents such as Appendix G, Part 1, Mine Waste Plan. Not hidden well enough, comes to my mind. There had been several requests to remove it from all documentation over the last year, and yet here it is again, like a bad smell. Assurances were given, but it appears not to be formally ruled out. This uncertainty is creating real and growing concern for third parties that it could be used somewhere else in the process, and is deeply worrying. Mr. Bill Donnelly, respected objector against the Cavanagh mine over many years, reminded the Commission that the mine at Cavanagh has planning permission for the use of cyanide, that it simply had to apply to the NIEA to install a cyanide reactor to process its ore, and it would be rubber stamped through. That was never included in the Habitats regulation statements, and that it cannot be ruled out that Dalradian could process their ore in Cavanagh instead of Nova Scotia, as outlined in their application. I think the day ended with the conversation about project splitting as raised by third parties in the statement of case. As there are 8 different planning applications ranging from power to water to road abandonment, I would have thought it was pretty obvious to the dogs in the street that it was project splitting in an effort to avoid an environmental impact assessment. Usual standard mining practice as outlined in the mining handbook. Get one bit through and the rest will follow. That's all I have for you this evening. Onwards and upwards. See you tomorrow.